So far we learned about two non-constitutional bodies which become a part of the anti-corruption framework in India. Firstly, we learned about the Central Vigilance Commission. Secondly, we learned about the Central Bureau of Investigation. Both are very important non-constitutional bodies. The next two bodies, which is Lokpal and Lokayukta, are also become part of anti-corruption framework in India. However, before that, let's understand what the system of ombudsman is, because Lokpal and Lokayukta has been established taking inspiration from the institution of ombudsman. So, ombudsman is the world's first democratic institution for addressing ordinary citizens' grievances. So far we were talking about public administration and public servants or officials or uh, essentially bureaucrats, all of these people who are involved in public administration, right? If at all they are taking an action against a citizen which is out of their specified powers or authorities, and by that an unfair treatment has been meted out to a citizen, the citizen needs some sort of an outlet to convey this unfair treatment or administrative arbitrariness that has caused to him, right? So for that, an ombudsman was appointed, and this ombudsman was first established in the Scandinavian country of Sweden in the year 1809. So very early in the 19th century, the institution of ombudsman was established in Sweden. So it is a fairly old institution. It has a very long history. So the term ombud in Sweden means representative or attorney or proxy. So essentially, he hears the grievances of the people and becomes a representative of the ordinary citizens before the three branches of the government. Speaking of which, government has three branches, right? So government has legislature, it has an executive, and it has a judiciary. The legislature makes laws, executive implements laws, and the judiciary interprets the laws. So in Sweden, the ombudsman was appointed by the parliament, which means the legislature. And ombudsman has the power to keep an eye on or check on the activities done by the executive and the judiciary, and it even had the power to keep an eye on the military actions as well. So ombudsman in Sweden was quite powerful, and it was also independent from the legislature, so it has absolutely no influence by the legislature cannot exert its influence or power on the ombudsman, and ombudsman had the power to keep an eye on the activities of the executive, judiciary, as well as military. So, what were the duties of ombudsman? Ombudsman looked into several administrative actions taken by the executive or the judiciary or the military, and looked into complaints regarding administrative arbitrariness or administrative excess. If at all the administration is inefficient, then ombudsman can also uh, look into those matters, and if at all there is issue of corruption, ombudsman look into those complaints as well. Coming to the jurisdiction of ombudsman in Sweden, ombudsman had the power to look into a matter or cause an inquiry into a matter which is complained to him, which is brought to him as a complaint. Or ombudsman, if he himself comes to know about some kind of an administrative arbitrariness or judicial excess, then he himself can initiate an inquiry, which means he had suo motu jurisdiction as well. And ombudsman in Sweden is not free from accountability because he had to submit an annual report to the parliament. So in that way, ombudsman has also been made accountable. And if at all there is no confidence in the person who is appointed as an ombudsman, then he can be removed from his position. So it is not that ombudsman becomes all too powerful and then he starts misusing his position. It is not the case. He can also be removed if at all there is no confidence in this person who is appointed as ombudsman. And ombudsman did not have the power to regulate administrative actions or interpret laws. So Whatever is executive's domain will remain as executive's domain. Executive is there to implement laws, and whatever is judiciary's domain will remain as judiciary's domain. Judiciary is there to interpret laws, right? The ombudsman did not have the power to change the course of law or interpret laws or regulate administrative actions. No, it only had the power to look into administrative arbitrariness. That was the limit of ombudsman's jurisdiction. And once ombudsman has done an inquiry into a complaint, then the ombudsman will file a report based on the investigation or inquiry. He will file the report to the higher official. So if a complaint is made regarding a public servant or a public official, whoever is that public official's higher official, that higher official will receive the report from the ombudsman, and ombudsman will recommend what action shall be taken against this particular public official. So this is the system of ombudsman essentially. This system of ombudsman then started spreading to other Scandinavian countries such as Finland, Denmark, and Norway. New Zealand was the first Commonwealth country to get inspired from the system of ombudsman and establish their own system for redressing grievances of ordinary citizen, which is known as the Parliamentary Commissioner for Investigation. So this was instituted in 1962. UK then came up with its own version of ombudsman, which is known as the Parliamentary Commissioner for Administration in 1967. In France and certain other European countries, they have administrative courts instead of ombudsman. And in socialist countries such as Russia, they have procurator system. Essentially, they are all democratic institutions to address the grievances of ordinary citizens. So, Lokpal and Lokayukta has also been established by being inspired from the history of ombudsman other similar systems. So, following the footsteps of the Ombudsman system and the Parliamentary Commissioner for Investigation in New Zealand, the Administrative Reforms Commission, which was there from 1966 to 1970, headed by Morarji Desai, recommended the establishment of a Lokpal for the centre and Lokayuktas for the state. This Lokpal was recommended to be appointed by the President in consultation with the Chief Justice of India, the Speaker of Lok Sabha, and the Chairman of Rajya Sabha. And as far as possible, this appointment has to be non-political. These institutions will be independent and impartial, and their proceedings and their investigation shall be done in private and as informal as possible. And one deviation from the ombudsman system was that judiciary will be kept out of the purview of Lokpal. So in Sweden, even judiciary came under the ambit of ombudsman, but however, the Administrative Reforms Commission said that judiciary shall be kept out of the system of Lokpal and Lokayukta. However, the proceedings of Lokpal and Lokayukta will not be subject to any kind of judicial interference as well. So, yes, this was the Lokpal and Lokayukta that was proposed by the Administrative Reforms Commission. So, even though comprehensive recommendations were given by the Administrative Reforms Commission, nothing came out of it. Following those, several bills were also introduced to establish the system of Lokpal and Lokayukta. In 1986, a Lokpal bill was introduced, however, it lapsed due to the dissolution of Lok Sabha. Other bills that were introduced following this also met with the same fate. Nothing materialized. But states started enacting state laws and started establishing lokayuktas. So Maharashtra was the first state to establish lokayukta in 1972. Finally, in 2013, the Lokpal and Lokayukta Act was enacted, and it seeks to establish a Lokpal for the center and Lokayuktas for different states, just as the Administrative Reforms Commission envisioned. So the Lokpal's jurisdiction includes the Prime Minister, ministers, member of parliaments, Group A, B, C, and D officers and officials of the central government. So even though the Prime Minister is under the purview of Lokpal, It is a very limited jurisdiction that the Lokpal has on Prime Minister. There are several limitations on the actions that can be taken against the Prime Minister by the Lokpal. Coming to the composition of Lokpal, Lokpal consists of a chairperson and a maximum of 8 members, and 50% of these members shall be judicial members, and 50% of them shall come from the scheduled caste or scheduled tribes or OBCs, minority groups, or shall be women. So, and the selection of this chairperson and other members shall be done by a selection committee. Now, the selection committee will consist of the Prime Minister, the leader of opposition in Lok Sabha, the Lok Sabha Speaker, the Chief Justice of India, or a sitting judge of the Supreme Court who is nominated by the Chief Justice of India, and an eminent jurist who is nominated by the President upon the recommendation of the first 4 members. So, the Prime Minister, the Speaker of Lok Sabha, the Leader of Opposition Lok Sabha, and the CJ or the sitting judge nominated by the CJ will recommend an eminent jurist, and upon this recommendation, such person shall be nominated by the President to be a member of the selection committee. The Lokpal will also have power of superintendence and direction over any investigating agency, including the CBI, for the cases referred to them by the Lokpal. And institutions that are fully or partly financed by the government also comes under the jurisdiction of Lokpal. However, government aided institutions are excluded from the ambit of Lokpal. Lokpal Act also contains several provisions for strengthening CBI. The Act also provides for certain timelines for finishing a preliminary inquiry. Lokpal can take 3 months, however, it can be extended by another 3 months. For finishing up investigation, Lokpal can take 6 months. Again, it can be extended by another 6 months. For finishing up trial, Lokpal can take 1 year, which is again can be extended further by a year. And the Act also protects honest and upright public servants. So these are the major features of Lokpal. Now, what are the issues associated with Lokpal? We discussed the Whistleblowers Protection Act of 2014 previously, right? The major issue with respect to that act is that it has still not been notified by the government, which means it's still not operational. It has not come into force yet. Lokpal, even though it has been notified, it has not been fully functional, even though it has been 10 years since the enactment. And very few complaints have been received by the Lokpal, and most of the complaints received by the Lokpal has been frivolous complaints. The Act also prescribes heavy punishment for filing false or frivolous complaints, which might deter people from coming forward to the Lokpal and filing their complaints. And there is a limitation period of 7 years, just like in the Whistleblowers Protection Act. We said that if it has been 7 years or more since the action that has given rise to the complaint, then the competent authority will not have jurisdiction. Similarly, Lokpal also cannot look into an incident that has taken place 7 years or even beyond that. And Lokpal, unlike the Ombudsman in Sweden, does not have the power to take suo motu actions. And Lokpal also does not entertain anonymous complaints. The Whistleblowers Protection Act also does not entertain anonymous complaints. The PIDPI resolution also does not entertain anonymous complaints. Yes, there is an aspect of protecting honest and upright public servants. However, this feature might also deter people from coming forward with complaints to Lokpal. Speaking about Lokayuktas, as I mentioned, many states had established Lokayukta even before the 2013 Act. It was Maharashtra who established it first in 1972. By 2013, 21 states and one union territory, which is Delhi, had established Lokayukta. However, there is absolutely no uniformity as to how states have established Lokayukta or with respect to qualifications, with respect to jurisdiction. So let's see some of the areas where they differ. So, with respect to the structural organization of Lokayukta, some states have just appointed Lokayukta, such as Bihar or UP or Himachal. Whereas states like Rajasthan, Karnataka, Andhra Pradesh have established Lokayukta as well as Upalokayukta. So, two authorities. And in some states, such as Punjab, the authority has been designated as Lokpal instead of Lokayukta. So, even with respect to the structural organization or the name of the authorities, there are differences. Secondly, when it comes to appointment, there is somewhat of a uniformity. Generally, they are appointed by the governor, and the governor does so in consultation with the Chief Justice of the State High Court and the leader of opposition in the State Legislative Assembly. Another area where they differ is with respect to qualification in some states such as Himachal, UP, Karnataka, and Orissa. Qualifications of Lokayukta have been prescribed. However, in some states, absolutely nothing has been prescribed with respect to qualifications such as Bihar, Maharashtra, and Rajasthan. With respect to tenure, they are generally appointed for a period of 5 years or until they attain the age of 65 years, whichever is earlier. With respect to jurisdiction, in some states such as Orissa and Rajasthan, the chief minister is excluded from the purview of Lokayukta, uh, whereas in some states such as Himachal or Andhra, chief minister also comes under the purview of Lokayukta. So once again, there is no uniformity when it comes to jurisdiction as well. However, in most states, Lokayukta has the power to initiate suo motu investigation, which we saw that in the case of Lokpal, it does not have the power to initiate motion on its own. But however, Lokayuktas in most states have the power to initiate suo motu investigation. But in the case of UP, Himachal, and Assam, suo motu power to investigate does not exist. And with respect to the scope of cases covered in some states, both allegations of corruption and maladministration can be looked into by Lokayukta. However, in some cases, Lokayuktas can only investigate corruption allegations. They do not have the power to investigate allegations regarding maladministration. So there is no uniformity in how Lokayuktas have been established in various states, and the state of Lokpal in the country, even though the act was enacted 10 years ago, is still not satisfactory. So you see, these two institutions, which were supposed to follow the footpath of Ombudsman and other similar systems in other jurisdictions, which started off as a very ambitious goal, has still remained somewhat of a goal, and we have not yet realized this goal yet. So these are the non-constitutional bodies: the Central Vigilance Commission, Central Bureau of Investigation, Lokpal and Lokayukta, which forms part of the anti-corruption framework in India. Now, to make this more comprehensive, we will look into three important judgments on prevention of corruption. Coming to the landmark judgments on anti-corruption, firstly, we will learn about Vineet Narayan versus Union of India. I've already mentioned this case before, but let's move on to some of the details of this case. As somebody who is learning about the anti-corruption framework in India, this is a very important decision that you should know. What happened in this case? Let's start with the facts. Ashfaq Hussain, who was alleged to be a member of Hizbul Mujahideen, which is a terrorist organization, was arrested in Delhi in March 1991. While the law enforcement agency was questioning him, he revealed that his organization was getting funds through Hawala transaction with the help of a Surinder Jain and his family. What is Hawala transaction? Before that, all of you must have heard the term black money and you must know what black money is. Black money essentially is illegal money. You are not supposed to be in possession of black money, and you are not supposed to transfer black money to somebody else. We will learn what illegal money or black money is and how that money is laundered, which is a process known as money laundering at the end of this unit. But for the time being, just keep in mind the term black money. Okay. So Hawala transaction is a way of transferring black money without the actual transfer of money. Let me explain that. Okay. So suppose there is a person in country A. Okay, there is A. There is a person A in country A who wants to transfer 10 crore black money to a person B. Say this person A is in India and this person B is in US. So because this is black money, A cannot just go to a bank or a money transfer service and just ask them to transfer this money to B. This will attract the attention of law enforcement agencies, and that money can obviously be traced back to A. Now, that is a problem. A will approach a Hawala agent in his country and he will transfer this 10 crore rupees to this Hawala agent. In return, this Hawala agent will give a unique code, sort of like the OTP that we receive. Okay. Hawala agent will also receive some sort of a commission from you. Obviously, Hawala agent is not doing this for charity. He is doing it for money. So this Hawala agent will then intimate to a Hawala agent in country B to give B the equivalent amount of 10 crores in US dollars. So B will give this money, but before that, the Hawala agent will give this money to B, but before that, B will have to give the Hawala agent the unique code that was given to A. So A will give money to this agent will give a unique ID to A. A will share that ID with B. B will give that ID to this Hawala agent, and then Hawala agent B will transfer the equivalent money in US dollars to person B. I hope that is very clear. This is what a Hawala transaction is. So this person, Ashfaq Hussain, was saying that a person named Surender Jain and his family has been giving us funds through Hawala transaction. So when this allegation was made, CBI raided the premises of Surendra Kumar Jain, his brother, his relatives, all the businesses. From this raid, they received Indian and foreign currency as well as they received two diaries. And these diaries contained information regarding certain payments made by different persons. Now, the name of the persons were not written, it was just the first letter of their names written. However, it was eventually found out that these are the names of very high ranking politicians, bureaucrats, etc. When this information came to light, CBI suddenly stopped investigating. And CBI officers who were involved in the case were actually transferred to other places. Now, obviously, the public will lose trust in such a big institution like CBI when this happens, right? So, in 1993, a public interest litigation was filed in the Supreme Court alleging that CBI and other government agencies have failed in fulfilling their public duty by not investigating the Jain diaries, and that the investigation was stopped to protect the persons who were involved in this case. So this case is not just related to Jain diaries, but it was also about having a free and biased free working of government agencies. So the main issue before the court was unsatisfactory functioning of government agencies, mainly CBI and the Enforcement Directorate or ED. So in 1993, the government constituted a committee headed by then Home Secretary N.N. Vora, which looked into the activities of crime syndicates, mafia organization, which had developed links with and were being protected by government functionaries and political personalities. The report of the committee said that mafia is virtually running a parallel government. The mafia in the country had become so powerful that they were running a parallel government. And the court was convinced from this report that there is a need for improving the procedure for constitution and monitoring the function of intelligence agencies. So, taking into consideration of the recommendations of the committee, Supreme Court gave directions to give the Central Vigilance Commission statutory status. Court also gave a direction that CVC shall be responsible for the efficient functioning of CBI, and CVC was directed to have superintendence over CBI's functioning, which means that whichever investigation CBI is handling, CVC will have a supervising role. So that is why this case is extremely important. Moving on, the next case is a very recent case. A decision was given by the Supreme Court recently in November 2022 regarding the value of circumstantial evidence in bribery cases. So, for some reason, there are no direct evidences in a bribery case. Direct evidence, as in primary, oral, or documentary evidence. There are absolutely no such evidence. Maybe the person who was forced to give bribe has died. In those cases, what happens? So the court held that if there is no primary or direct evidence, in that case, court can determine the culpability or guilt of the public servant using circumstantial evidences. So, direct evidence in a criminal case is obviously the most important type of evidence. Suppose there is an eyewitness to this particular alleged event. In that case, that is a direct evidence, there is an eyewitness. But suppose there is some sort of a documentary evidence. Okay, suppose this person has requested money through a WhatsApp message or through an email, then that is a documentary evidence. These are direct and primary evidences. Okay, so in the absence of any of these evidences, if there are other circumstantial evidence that is there, then obviously that can be looked into by the court. But court also added that foundational facts have to be proved in that case. Court also said in this particular order that to prove the demand and acceptance, certain aspects have to be kept in mind. In some cases, someone offers bribe without any demand, because this culture of offering bribe has become so normalized in our country. It has been ingrained in our brains. If a person offers bribe without any demand, and if the public servant accepts that, even in such cases, acceptance can be punished under Section 7. And the last case that we are going to look into is Bank Securities and Fraud Cell and others versus Ramesh Gelli and others. So in this case, what happened was that there was a private bank which merged with a public sector bank, and there was an allegation leveled against the certain officers of this private bank. So as we've learned in Prevention of Corruption Act, only public servants can be punished under this particular act, right? So the question here before the court was whether officers of private bank are public servants, and the court held in affirmative, which means the court said that yes, officers of private banks can be considered as public servants under Prevention of Corruption Act.